Alfredo. Good morning, everyone. It's a pleasure to be here. Thank you very much, Benita. Thank you, Javier, and Cremades law firm. It's a pleasure to be here with my friend James Black. We have some old friends from last year and some new friends now. I'm really pleased to be here. Well, I will talk briefly about big data and the legal challenges that it poses to our profession, and how can data protection law deal with big data. Of course, I will take a Brazilian perspective, but I will try to make some comments once it's a very new legislation in Brazil, and it was very much inspired in the European GDPR. Well, big data, in case we're not everybody aware of what is it, it's a massive volume of data that comes from different sources and databases which are publicly available, and some of them are privately available. So when you have a massive volume of data, a huge volume of data, it poses to technology a big challenge that you need a very high level of computing processing, and in our legal side, it poses how this data was collected, how this data is treated, and how this data is divided. We have some different uses to big data. Google, for example, has data from different sources. It crawlers billions of data of web pages searching for data. It gets data from search requests, and it gets data from different databases. And of course, with all this data, it increases search experience. So we have a very good experience while we are using Google in comparison to other search engines. They have a very good level of offering of AdWords technology, which makes it very accurate in comparison to other technologies as well. But we also have other different sorts of sources of big data. Let's take one example, mobile phone applications. Everybody here has mobile applications in their phone, and of course, most of them, they collect data that we have. They collect location data, so they're able to identify where do we live, where do we work. So is anybody here who uses Waze app, for example? I think it's very much used in South America, much more than in the Americas than in Europe. But it says, where do you live? So, for example, every time that I wake up, then it's asking me, so are you going to work? You have like 15 minutes for you to arrive in your work. And of course, when you collect data from citizens, you can give multiple uses. So there comes a data-based business. So if you have, there is a company in Brazil. In Brazil, we have a little bit more than 200 million people. So there is a company that has the locations in real time of more than 15 million Brazilian residents. So if you have the location of these people, what would you do in terms of commercial? What sort of use can we give it? So for example, you can use it for identifying where somebody is living for the purpose of opening a bank account, for example. In traditional banking, you have to prove where do you live by a document. And with these sorts of data, they were able to open a new way to opening a bank account in online banking that makes everything faster. And of course, you can say it might be a very big issue to privacy, but in the end of the day, if the consumer is informed, it's a trade-off that you might choose. So you're going to have the easy way to open a bank and other services that you can get from some third party to have your data, or you prefer not to have it. I think it's much more deal with it. And of course, big data has all sorts of, this sorts of crawling and getting data has all sorts of data, including personal data. And it, oh sorry, what's that person? And it poses different challenges to data protection law according to each national legislation and each national structure. So for example, in many countries in the European Union, you have the Data Protection Authority. It's a legal standard. In some countries, you do not have the Data Protection Authority. So it gives room to different challenges in each country as well. In Brazil, we have a very, very recent law, the Brazilian General Data Protection Law from this year, Lei Geral de Proteção de Dados, la Lei General de Protección de Datos, that was, as I just said, was approved in both houses of National Congress and received presidential approval in August 2018. So it was just after the date that the European GDPR came into force. There was a lot of pressure in the Brazilian Senate and the Brazilian Deputy House, and then we have this new law. It was very much inspired in the European data protection law, and it defines personal data as information related to an identified or identifiable individual. So it also gives room for sort of protection that goes beyond the individual identification. So it just needs to be identifiable, much similar to the European GDPR. It's applicable to both private and public controllers and processors. We have the same concepts that you have here in Europe of controllers and processors. Very, very, very similar. And we have 10 lawful bases for collection and processing of data. But we had a problem the very last time. We knew there was a legal issue that in Brazil, for you to create a new agency, it needs to, the bill of law needs to come from the President of the Republic. But this one came from the Senate. So in the end of the day, there was a veto to the creation of national authority. It's promised that we're going to have very soon a new bill of law that might create this national authority, but it also poses very big challenge to Brazilian companies, because there was a lot of lobby from the IT industry, because people were saying that there would be some sorts of audits in the algorithms. So Brazilian companies got scared, and there was a lot of lobby for this veto as well. In the end of the day, we're going to have a scenario where to enforce this law, any individual might enforce this directly to the law courts. We're going to have some other authorities that are not specialized on this. So for example, we will have the Public Prosecution Service in Brazil that will be able to, in the aim of protecting the individual's rights as a collectivity, they might be able to sue the companies. And other services as well. We have the Brazilian Consumer Protection Agency. We have some clients that already received, based on the last law. We had a previous law on data protection just applicable to Internet Service Provider, and the Public Prosecution Service sent many notices to them, asking a lot of information of how they're processing the data. And we really believe that in the first day that this law comes into force, which will be in the February of 2020, there will be a lot of problem if we do not have a national authority that might give orientations, that might give some comments for companies to know how to comply to the law. Because of course there are many technical standards that needs to be fulfilled and clarified. And when it comes to our law, one of the main challenges is about the crawlers. As I said, crawlers, they're software that they look for information throughout the web. So they get this information, they collect this information, and then they store this information. And the first issue is that what are the sources of these informations that are being got from crawlers? Most of them, they're public available information, but there's a question. Was this information provided by the individual, the data subject, or was it published by somebody else? Brazilian law makes a difference where the public available information was provided by the data subject. In this case, there is no need to informed consent. Actually, it is one of the lawful bases for one to collect this data. It doesn't mean that once that you collected, you do not have to comply with data protection principles. The principles are still safeguarded, but you just do not need to have an informed consent, which is normally the first legal basis for one to collect personal data. And the other thing is that these crawlers, they also might work together with databases that are privately available. And in this case, of course, one needs to have the consent or some of the other 9 lawful bases for data collection. The second issue that big data raises in Brazilian law regards the data lakes. Data lakes are big databases that are formed, that are made out of different databases. So, for example, in Brazil, there is a very famous credit protection service that has the data of millions of Brazilians or Brazilian residents. They normally were selling these databases on the lack of legal provision, of legal safeguards to our citizens, and many services, they were putting this together with different databases. So, for example, we know one company that has more than 200 different databases, and it formed a big data lake. It's called data lake, when you put together different databases of people, and you might create also different data-driven businesses. And of course, the first issue is that how is this data processed? We talked about the collection of data for these data lakes has the same issues and the same nature that you can get from public available information or databases and privately available databases. One of the ways for one to protect or to be in compliance with Brazilian data protection law is just to anonymize this data. But when you anonymize this data, it falls out of the concept of personal data, in the meaning that this might be collected, but it might be used, but still there are some standards of law that needs to be complied with. It just falls out of anonymized data when, of course, this anonymized data is reverted by one's own means, and this is the expression used in Brazilian law. It means that you should not get together different processing capacities for one to be able to make a higher level of computing processing. And it cannot be capable of being reverted with reasonable efforts. And what is reasonable efforts in Brazilian law? It provides that for one to understand if the reversion of anonymized data is being made by reasonable efforts, it will take objective criteria. And it says expressly that it will take into account costs and time necessary for reversion of the anonymization process, according to available technologies and the exclusive use of one's own means. So we were talking before about blockchain. Blockchain has a huge capacity of processing. So if you're using a collective of computers to process this, it might also not be compatible with the Brazilian reasonable efforts to know if a data can be this anonymized. So I think this was it. I will be more than happy to discuss any questions. I just gave a very brief overview of Brazilian law, and thank you very much.
Brilliant in both cases. Benita, Diego, please let me make a little simple question before we conclude. You two, do you think that companies consider as an advantage to show before their customers that they are personal data responsible, or do they consider that GDPR is a cost, or consider that the new regulatory framework is a loss of business due to the fact they cannot continue making use of the personal data that they made before?
I think there are the two views are valid. There were some companies in Brazil that they were very much against the data protection law because, of course, to medium and small size business, that's going to be a real problem, as Black has just said. But there is another way of viewing it as well. I think if companies, they start to make their business very much based on the privacy by design concept, that's going to be easier for them. And there is, we have a client in Brazil that make data processing, and they have a data-driven business. What they're doing after the GDPR, the Brazilian GDPR, is that they're taking it as a social responsibility because they're a very famous Brazilian company, and they're making seminars for people and for companies to understand how one can get in compliance into Brazilian data protection law, and that might be not that difficult if you take into account the privacy by design concept. So in the end of the day, I think it's not a question that you might like or might not like being in compliance with data protection. I think it's something like the first copyright laws. In the beginning, there was no protection for works, and someday there was a protection. The first one was the French and the British one, but there's a new stage that privacy and data protection needs to be enforced. So companies need to be aware of it, and I think it's our job as well to make sure that everybody understands it better and how can it be made very easy.
Thank you. I think the answer is both. That any good marketer will be able to spin it and come up with good reasons why it's helpful to them to be GDPR compliant. However, until they can figure that out, I think there's going to be a lot of complaints in the U.S. that it's too hard, I don't know how to do this, I don't know how to comply, it's a risk, I'm going to lose customers, I won't be able to data mine the way I used to. And the quick answer to that is, well, you're not supposed to be allowed to data mine the way you used to. People don't want you to data mine. That's the whole point. I think in the end, most businesses will use this as they develop compliance, will use it as a marketing tool saying, I can do this. But until they get there, I think instead the first reaction is going to continue to be, I don't know, I'm afraid, I don't know if I can do this. The natural reaction in the U.S. from business and business advocates is, regulation, you're going to kill my business. That's the first reaction. And then they realize, well, wait a minute, maybe we can do something with this. And then they acclimate to it.
Okay, thank you very much.